for something that happened 24 years ago. So, my lord, I have a slightly different issue. I'm not on this.
Whichever appeal is substantive, in your view, will take up first.
Sorry?
Whichever appeal is substantive.
Lord, mine is.
Your perception will take up first.
Lord, mine is a very substantive issue because I was not a party.
By serial number.
Yes, I was not a party. And unfortunately, my lord, what has happened is in my absence, the learned judge has not condemned me beyond imagination. That's why I'm before your lordships. So, my lord, I am ultimately now, my lord, facing a prosecution. Learned judge has commented upon the merits of the prosecution and has left no remedy now available for me. So, my lord, I would like to show that.
Matter, my lord, in 20.1 and 20.2, I appear, my lord, for respondent number 4 and respondent number 1 respectively. Your lordship may kindly see 20.2, my lord. All the only order that has been passed by the single judge.
It's my petition. Why do you want to interrupt just now?
Is to
Mr. Raghavan, it's my petition. Please allow me. Do you have any preliminary objection or what?
Yes, with respect to 20.2, yes.
Correct. By suppressing vital documents, these orders have been taken. I will show to your lordships.
Appeal will consider.
Sorry?
You are seeking leave to appeal.
Yes, my lord.
So we'll consider.
Yes, my lord.
Let the first main subject matter be addressed.
Lord,
your lordship may take up his matter first, brothers. Your lordship may take up his matter first. I'm in the first matter. Let that be done first. No problem.
Lord, I am grateful to Mr. Singhvi. Lord, just turn to page, Lord, 88.
Which one?
Take up Lord 1713 of 2024. 20.1.
But all will travel together. We may take up first, no difficulty.
Yes.
But all three appeals will travel together.
Yes, of course. But Lord, I stand slightly on a different footing because I was not a party and I have suffered. Lord, one principle that has been settled.
We understand, Lord, but even then all matters will travel together.
Of course, Lord, they will
as
travel.
Far as the procedure and decision.
Today I am more anxious than them because I am facing, Lord, this condemnation in my absentia.
All are appearing in your matter. All respondents are appearing.
Lord, they were.
Notice,
your lordship.
last time, Lord,
last time they appeared, Mr. Maninder Singh, Mr. Raghavan, learned Solicitor General, they were all there. I don't know which matter they appeared.
Notice is not at issue. Notice may have to go.
Yours,
complainants are on caveat, my lord.
Yours is 1713.
Yes, my lord. And 1719. Both.
But right now, leave to appeal is 1713.
Yes, my lord.
Who are the respondents? All are appearing.
Lord, they are on caveat. Yeah.
Number 3 appearing.
Page 6, my lord, they are on caveat. The complainants.
20.1, my lord, respondent number 4.
3, 4, 5 are on caveat.
Notice may have to go to respondent number 2, my lords.
I'm appearing for the state in this matter. I'm appearing for the state.
Appearing for the state.
State,
number 1.
Please.
But the notice will do number 2 and 5. 2 and 6.
Tushar Smith had appeared before the learned single judge. Notice may have to go. Only after that, probably.
Lord, I am really not concerned about 17A order by the Excellency, the Governor. That's between them.
My lord is saying all must travel together. That's in that context. My lord.
Only thing that you may be separate.
Yes.
But at least in hearing part, we can't disconnect the things. That is what we are suggesting.
Lord, I would respectfully urge.
We'll treat you separate.
Yes, Lord.
You are separate.
Because, Lord, I am getting dragged at the age of 80 in this, Lord, slugfest. I have nothing to do with politics.
You remain Jal Kamalvat.
I asked my client whether he voted for BJP or Congress. He said, neither. I voted for Janata Dal. So, my lord, why should I suffer because of all this?
You have to suffer because you are the Janta.
So, my lord.
Lotus in a water doesn't have the touch of water.
Yeah, that's
so
true.
We'll keep you like that.
Very well.
But still, it will be in the water.
Yes, yes.
So, notice.
Yes, my lord.
Which date?
Lordship, sir. Lord, I have one prayer. Lord, last time what happened, your lordship knows by consent on 22nd it was adjourned. And everybody had agreed that learned single judge would be requested to Lord adjourn the hearing. Lord, my distinguished friend, Mr. Raghavan was not in the court before your lordships. So before the learned single judge, he Lord stoutly resisted a request for adjournment. So it should be understood. Now learned single judge has kept it on 10th. Either your lordships keep before 10th, I have no problem. Otherwise, Lord, if your lordships are unable to fix it before 10th, then your lordships may, it should be understood by all parties that matter. Otherwise, it will become infructuous, completely infructuous.
Why infructuous?
Sorry, because the learned single judge is now Lord post haste wanting to transfer the proceedings to CBI. No.
We do not.
That's the petition filed. That's what petitioners want. Learned single judge has issued notice on that.
How can you foresee a decision in any matter?
No, not foresee. The petitioners are insisting. Petitioners are insisting. So, Lord, I am respectfully submit. Either your lordships may protect me or your lordship. It should be understood. I am in your lordship's hands.
My lord, can I make one submission? my
I am
lord?
seeking, my lord, ex parte stay today.
Can I make one?
Undoubtedly, because, my lord, I'll show to your lordships what wrong is there in learned single judge, which is hurting me very
Who are you,
seriously.
by the way?
My lord, I am a farmer who in 2004 sold this land to the Honorable Chief Minister's brother-in-law, not knowing what is going to happen in 2024.
Why you are?
Well, I've been, my documents have been set aside by the single judge. Single judge says I am party to fraud. Single judge says I am liable. Single judge says I should face prosecution.
Why you are so much bothering after this much years?
No, my lord, why?
It's not-
Why
it's
should
not-
I at this stage and age, my lord, face this?
That will examine.
Lord, my life and liberty is at stake.
What Mr. Raghavan is saying, yes.
My lord, can I make one submission, my lord? Yeah, my lord, the anxiety that my learned friend is showing with respect to the hearing on the 10th is in 20.2. Please see the order that has been passed by the learned single judge against which this appeal is filed. All that the order says is, my lord, issue notice.
No,
It is
see the
against
last order.
That is all the order that has been passed. Nothing more. I ask myself, how is an appeal maintainable against an order simply issuing notice by the learned single judge? This is all that there is in
But
it.
see the last order, Madam Court.
Please see, my lord. Please see the order.
I will.
Kindly see the last order.
That is
Learned
fine.
judge now has peremptorily fixed it.
That is 511 order.
No, subsequent order on 10th, 26, on 26.
My lord, what is challenged, my
The
lord?
understanding is matter would be heard on the said date. Now, my lord, they can't seek adjournment here. And kindly hear me on, my lord, ex parte stay. I'll pursue your lordships.
Sir, my lord, my objection is to the maintainability.
511
I'm
the
now
order was
saying,
that the Lok Ayukt is directed to place on record the investigation.
That's all.
Yes, correct, but my lord, it affects me. I am talking about Article 21, my lord. Why should I be condemned without hearing? Lord, it goes to the root. There are 100 judgments of Supreme Court which says that if you have not been heard, it must be set aside. It's a simple thing, my lord. I'm praying to your lordships.
Only
Nothing,
the
my lord, big.
record of investigation conducted till particular date is ordered.
If this judgment qua me goes, this order goes.
There is no expression of opinion.
nothing.
No, nobody is saying. In this judgment, there is an expression of opinion.
My lord,
1713.
The matter coming
That
up.
is consequential.
No.
That is the second petition they filed.
Oh, you are saying that the proceedings may not go before.
Yeah, please see this, Lord. Kindly turn to page 88.
We are the least court to interject in the proceedings of other court.
I am not wanting your lordships to interject in other court. I am wanting your lordships to protect me here. Please turn to page 88. Let us see what the learned single judge has done. Kindly turn to page 88. I am only on my, my lord, case and why, my lord, I should be protected. Page 88, my lord. Please see the first issue. My lord, this writ petition was filed by the Honorable Chief Minister challenging the sanction granted by Honorable Excellency the Governor under Section 17A of the Prevention of Corruption Act. It had nothing to do with the complaint. Now see first issue that learned judge framed. Whether the petitions before the Governor and the complaints before the concerned court were justified in the fact situation. Page 88. Page 88, issue number 1. Whether the petitions before the Governor, fair enough, that was the subject matter before learned single judge, and the complaints before the concerned court were justified in the fact situation. Now, complaint is against me also. I'm accused for. I'm not a party here. Learned single judge without any necessity, because the issue only was whether the Honorable Governor was right or wrong. Now please see finding at 232. And before I show other pages, please see 232, Lord, state. Please kindly turn to 232. Summary of findings. I have been condemned, Lord. I have no remedy now. The complainants were justified. 232, Lord. First finding. Complainants were justified in registering complaint and seeking approval at the hands of Governor, or seeking. Registering complaint. Now, which, Lord, trial court today will give me benefit? Now, see the findings against me at pages, Lord, 93 to 97 first. 93 to 97, Lord. Lord, I'll tell your lordships briefly what happened. Lord, this is just kindly give me five minutes, Lord. Lord, this is a land which has been in my family since 1935. Lord, in 1968, Lord, this land was relinquished by me in favor of my other brother, my elder brother. Then it so happened that elder brother went into debts. And my lord, he passed away, unfortunately. His wife, son, and the other surviving brother, all of us agreed, appeared before the revenue authority in what is known as the inheritance khata, as my lords would tell. In my lord, the authorities recorded that my brother's widow, her son, and my other surviving brother have now relinquished the right in my favor. The land was accordingly transferred in my favor. All these facts are suppressed from the court. And suggestion is being made that although you are not the owner of the land, you sold it in 2004. Now, which is incorrect because it is recorded on revenue and all the records are before your lordships today. I can show. Now, my lord, that happened. Then, my lord, the acquisition proceeding started. And before, my lord, in respect of my land, an individual award was made. I had moved an application for withdrawal of the acquisition under section 48 for denotification, which was recommended by a committee consisting of large number of members, including members from the Bharatiya Janata Party, Congress, Janata Dal, everybody in Muda. It was sent to the government. A committee of 6 secretaries of government of Karnataka considered that, and along with some hundreds of cases, denotified my land. I am not the individual alone who is benefited. Now, if that be so, then my lord, that denotification. Now, see at page 97, what does the learned judge say? Please see. Lord, after recording, and Lord, unfortunately, the petitioners did not inform the learned judge of full facts, although they got Lord, full record, but they selectively placed it before the learned single judge. So, Lord, I don't blame learned single judge for these findings. It's the petitioners who have misled the court. 97, Lord, just first at the top. Based upon the said proceedings, and notwithstanding the fact that the amount of award was also deposited before jurisdictional civil court. Now, Lord, civil court returned that amount, which they don't disclose. Civil court said that the amount is not deposited for individual plans. The land comes to be denotified. This, on the face of it, is illegal act on the part of the state. Now, Lord, denotification in my favor in 1998, learned judges commented in 2024. My right to property is seriously affected. It's a constitutional right under Article 300 capital A. And I have sold it for a valuable consideration under a registered sale deed in 2004 for 5,36,000 rupees. Now, Lord, please see at page 100. Please see. Page 100, my Lord. First paragraph, last 5 lines. Mudda does not stop at that. Continues to form layout and distribute sites in favor of allottees. From 98 to 2003, owner of survey number 464 is shown as Mudda. Encumbrance certificate also reflects Mudda. Upon date of acquisition, it reflected name of Mallaraya, nowhere reflected name of Devaraju. Now, this is absolutely incorrect because, my Lord, the land record shows my name again and again for various years. From 91, 92, which was not, my Lord. Here springs the picture, family of Chief Minister. I am not concerned, my Lord. Devaraju, who claiming to be son of Ninja, para 21, executed a sale deed in favor of Mallika Jodnaya. He is a brother-in-law petitioner. Sale deed is executed on 25/8/2004, but sites were formed. Now, not sale deed in 2020 years ago. Who knows what will be the value in 2024? Learned judge says in 1935 value was 300 rupees. It is today 56 crores of rupees. Lord, how am I concerned as a small man? Now, my Lord, please kindly turn to page 104. Lord, the learned single judge. Please see at the 103 foot. What is discernible from the sale deed is none of the factors that have happened from 92 are even noticed. Devaraju was aware that subject land was included in preliminary notification. He was award final notification included. He submitted representation for denotification. Passing of the award is within knowledge. Deliberately, all these factors are suppressed and a sale deed is executed free from all history. But the land was already denotified. What is there to tell in the registered sale deed? Right or wrong? Nobody questioned it. And, my Lord, your lordships are aware, my Lord may perhaps tell your lordships, that in Karnataka, my Lord, denotification is nothing new. Because, my Lord, the farmers represent to the government and the government considers it. Now, my Lord, right or wrong, in 1998, denotification took place. 1998. Now, all right, if you want to, my Lord, damn me, at least the learned judge should have told the parties that join Devaraju as a party. So, my Lord, without joining me, the learned single judge, my Lord, has, now what is the, my Lord, consequence? Show me that compile that this note.
I don't want to interrupt my judge. I have a small suggestion.
Show me
But
this note.
this is a matter in
Quickly.
which,
It should have
your
ready.
lordships,
Please, hands.
consider it right or wrong. If your lordship decides to issue notice, then the matter will have to be heard. Right, now, if your lordship don't want to dismiss it ex parte and issue notice, then let it be heard. Right, all parties should be heard at that point in time. Right? That's right. That's ideal. Therefore, we will all request the learned single judge because it has ramifications.
Kindly give.
Right. Sorry, Malad.
We are not
My
coming.
lord, kindly see the law. My lord, your lordships are aware, but my lord, as recently as last week, I was sitting in Court of Justice, Dipankar Datta, my lord, and lordship set aside an identical judgment of the High Court where, my lord, observations were made and decision given against a party who was not before the High Court. Now that law is settled, your lordships are aware. My difficulty is that I am a criminal complaint is filed against me. With these findings, my lord, the criminal complaint, I will have no defense left.
My lord, can I make one submission, my lord? The matter,
One second.
Yes,
All
sir.
arguments of yours are liable to be considered on merits in respect to your prayer to leave to appeal, but not in connection with the staying of the proceeding to learn a single.
No, my lord, once your lordships grant me leave, I have a right to persuade your lordships to protect me. I am not, certainly, my lord, your lordships can't say that once your lordships grant leave, my lord, it's a right to appeal. And in appeal, I have a right to seek stay. Please don't drive me, my lord, from one court to the other. We are only respectfully urging your lordships that please do.
All our jurisdictional courts. You go there and whatever you request there, we are not coming in way.
No.
As Mr.
Lord, please see this.
Sibal is trying to balance the things.
My lord,
What I'm trying to
my
say,
lord, the learned judge, my lord,
all parties, because this matter has ramifications. It's not just this matter. Connected matters have ramifications.
Both.
Right? So it should not be that the right to appeal is lost by some peremptory order passed by the learned single judge. That's all that I am, as a state, concerned about, Mullahs. Either way, I'm neither for Mullahs this side or that side. But Mullahs, therefore, there should be an understanding that
Lord, we are in
till such
entirely
time
in
as
your
your
lordship's
lordship,
hands.
till
if
such,
your lordships may
till
decline
such-
me,
till such time-
I have no problem.
this time, no, one second.
If
Till
your
such
lordships are
time,
not
all
persuaded,
parties should agree.
I can't go beyond that. I can only persuade your lordships.
No, I'm
Ultimately, I have to bow
suggesting-
down. I have to bow down to your lordship's decision. But I need protection because not at 80 years, I don't want to face the criminal court. I don't want to face not police and CBI. Why should I do it? I have nothing to do with them. I sold it. But if today as a lawyer I sell land to somebody and in 20 years later if it's found that he is into criminal activity, should I be held responsible?
my lord, can I make one submission if my learned friend will kindly, my lord?
The only application probably would be, my lord, is it fixed at 10, 10th
Right,
at
a
2.
peremptory order passed by him.
No, my lord, I will tell your lordships, my lord, what
But
happened.
Raghavan, you should have joined me as a party. Why were you shying
One
away?
minute. Sir, I am not
You
a,
didn't join me.
in which petition? I am not the petitioner.
No, you took in your counter, you have made allegations against me. Despite the fact that it was governor's order, which was
I am
in
not the
consideration.
petitioner. Mr. Dave, I am
I will
not.
show your counter, Mr. Raghavan.
I am not the petitioner.
Serious allegations.
The petitioner is not me. The petitioner was Mr. Siddaramaiah. I was
Petitioner
not the
did not
petitioner.
do anything.
I was a respondent.
It was your counter which prevailed upon the learned judge.
Don't keep saying I should have made a party. How can I make you a party?
Mr. Raghavan, why are you not here today when we are here? I thought I would at least like to see you.
I would have loved to, but I had some other commitment which was a little unavoidable. Otherwise, I would have never missed being with you. And in the distinguished company of all of you, I would have loved to be there.